Three things that I want to cover tonight are as follows. I want to begin by looking at what I describe as the local government fundamentals. So it's a bit like local government 101. I want to talk about the way in which councils make decisions. I want to talk about the respective roles of mayor, councillor and CEO. So that's the first thing that I want to do. Perhaps, Linda, if we go to the next slide, you'll see all three. The second thing I want to cover are what I call the councillor conduct obligations. So what are the standards of conduct that councillors are meant to observe? What happens if it's said that a councillor hasn't met those standards of conduct? And then finally, I want to talk about what I call councillor integrity obligations. And here I'm going to focus on the concept of conflict of interest. When do you have a conflict of interest? What do you do if you have a conflict of interest? So all those three areas are really relevant to the legislative environment in which you'll be working over the course of the next 4 years. They're important because they need to be covered as part of the mandatory councillor induction program. So every councillor in the state needs to learn about these things. But I'm also covering them because I think it's important that you understand and have a good working knowledge of the sorts of concepts and some of the key provisions that we're going to look at this evening. So if I can begin with local government fundamentals and begin by talking a bit about the context, I think, in which we find ourselves in November 2020. Over the course of the past decade or so, there's been an incredible focus on integrity in the Victorian public sector. You've had IBAC, the Independent Broad-Based Anti-Corruption Commission, having been established and having in recent times played a major role in rooting out perceived corruption within the Victorian public sector. Most recently, you will have read or seen footage around the V-Line controversy. You've equally had the Victorian Ombudsman continuing to champion integrity and transparency of decision making. And it's not as though the local government sector has been spared from the interest of integrity agencies like IBAC and the Ombudsman. Again, we've seen IBAC play a role in local government through its inquiry into the city of Casey, which continues. We've seen the Victorian Ombudsman continue to publish reports that are relevant to particular councils or to sector-wide issues. And we've also seen in a local government context the local government inspectorate. The inspectorate's a unit within the state government, within the Department of Premier and Cabinet, which is dedicated to policing the Local Government Act. We've also seen the local government inspectorate as an integrity agency play a role in this space. So integrity has been a major concept over the last decade or so. So too have issues around councillor conduct. We've seen in some places unfortunate instances of bullying, intimidation, severe deterioration in relationships so as to render councils dysfunctional. We've seen obviously allegations of sexual harassment against the former Lord Mayor of the City of Melbourne. We've seen allegations of inappropriate interaction between councillors and members of council staff, some of which have spilled over and led to the state government intervening and dismissing councils. It's been the case in recent times, for instance, at the Shire of South Gippsland, the cities of Casey and Whittlesea. So how have the Parliament and the Victorian government responded to these challenges around integrity and concerns over the standard of conduct of some councillors at some councils? How have they responded to that? They've responded in the way that parliaments and governments perhaps typically respond when there's a problem. They've legislated. And they've legislated in this instance so as to impose even more rigorous standards of conduct on councillors and to impose even more onerous integrity obligations on councillors. And they've done that by toughening up conduct and integrity provisions in the Local Government Act. And here I'm talking about the Local Government Act 2020. For those returning councillors, you will remember that earlier this year we got a new Local Government Act which has introduced a number of reforms, including reforms around conduct and integrity, about which I'll speak more in a moment. Although for many years we operated under the Local Government Act of 1989. And interestingly, that 1989 Act still exists. There are some provisions in it that are still relevant. So perhaps all councillors need to understand that there are two Local Government Acts in operation. For the most part, tonight we'll be looking at the 2020 Act, but occasionally over the course of the next 4 years, or at least for the foreseeable future, you will sometimes see references to the 1989 Local Government Act as well, because some provisions within it continue. So that's enough about context and setting the scene. Let me now talk about who are councils and how do councils go about making decisions. There's lots of legislation in Victoria that says that a council must do something, imposes a duty on a council, or says that a council can perform a function or has a power or discretion of some kind. Now, when legislation is talking about a council, it's not referring to you as councillors individually, or for that matter, even collectively. What's being referred to is a body, what we call a body corporate, an entity in its own right, which the law recognises as a person, a legal person, if you like. And in your case, of course, it's Brimbank City Council, an entity which itself can enter into contracts, can itself buy and sell land, can itself sue and be sued. It's a bit like a company. If you think of BHP Billiton Limited, same concept. There's a body separate from the directors who govern it, separate from the staff who work for it, separate from its customers or clients. And so be conscious that when we speak about council, for the most part, we're talking about this body corporate, this entity in its own right. Now, how does this entity, Brimbank City Council, make decisions? There are in fact only two ways in which decisions can be made. And if we just go to the next slide, you'll see the two possibilities. The first way in which a council can make a decision is through a resolution at a duly constituted council meeting. And you'll have one of those monthly. There'll be a certain formality about it. There'll be rules of debate that apply, for example, and members of the public will have a right to be present, either physically or through live streaming of the meeting. Motions will be moved at one of those duly constituted council meetings. If a motion is moved successfully, it becomes a resolution and it embodies a decision of the council. Now, contrast those meetings, those duly constituted council meetings, with meetings of the kind that we're having tonight, more informal meetings, no rules of debate, no motions, no members of the public present. These sorts of informal gatherings of councillors will also take place over the course of the next 4 years. You have them, I think, each month. You have a strategic briefing session, I think, and a planning forum as well. These are not, however, meetings at which decisions can be made by the council. Therefore, information that the purposes. It might well be in a strategic briefing session that there's some consensus that emerges about something, and that may lead to the matter going on to a council agenda and a resolution ultimately being made. It could even lead to a member of council staff picking up what councillors effectively agree upon and themselves making a decision under delegation, which I'll come to in a moment. But those forums, those more informal gatherings or meetings, are not duly constituted council meetings. So possibility one for a decision is a decision of a duly constituted council meeting resolution. If we just go back to the previous slide, you'll see the second possibility is that there's a decision of a delegate. So the council can delegate decision-making power to somebody else. Now, some councils have delegated committees that make decisions. Some councils, especially regional and rural councils, have community asset committees to which some powers are delegated. But what you have and what every council in Victoria has is an extensive system of delegation given to members of council staff. Extensive powers are conferred on Helen to make decisions under delegation, and she in turn sub-delegates a number of more specific powers to other members of council staff. And decisions which they make, decisions which Helen makes as CEO, or decisions of other members of staff made under sub-delegations, are, as in the eyes of the law, are as good as resolutions made at a duly constituted council meeting. They are binding decisions of the council. Now, why do councils across the state, including Brimbank, delegate so generously to the CEO and in turn other members of staff? It's because if that's not done, decision making would come to a standstill. You're going to have a council meeting only once a month. Then not many decisions could be made until that next council meeting takes place. And even if you had a council meetings weekly, there'd be a build-up of operational decisions that would need to be taken. So hence the necessity really of delegating broadly to staff. So how does a council make a decision? Either by resolution at a duly constituted council meeting, or a decision of a delegate, and read for that, in your case, a member of council staff given delegated power. In either event, a document called the Governance Rules will say something about the decision-making process. It's particularly relevant for duly constituted council meetings because it will spell out how council meetings are to be held, rules of debate, the way in which motions can be put, adjournment of meetings, all those sorts of things. Returning councillors may remember that for most of their term, they operated under a meeting procedure local law, but towards the end of their term, that meeting procedure local law effectively disappeared and has been replaced by a set of governance rules. And those governance rules are also relevant to staff making decisions under delegation. And whether it be you sitting around the council table at a duly constituted council meeting, or whether it be members of staff acting under delegation, there are some guiding principles that you are meant to think about, and they're called the overarching governance principles. And there they are on the screen. You'll be relieved to know I'm not going to go through all of them, but I just do want to pick out a few. If you look at Section 9, subsection 2, paragraph A, you'll see that council decisions are to be made, actions taken in accordance with the relevant law. Well, that's straightforward. You would expect that to occur. In B, you'll see that priority is meant to be given to achieving the best outcomes for the municipal community, including future generations. And interestingly, in paragraph C, you'll see a reference to climate change and the need to consider mitigating climate change risks. If you go to right down the bottom to subsection 3, you'll see that in giving effect to these guiding principles, these overarching governance principles, there are what are called supporting principles that should also be taken into account. Principles spelled out in the 2020 Act around community engagement, which as the name suggests is about a council engaging with its community before certain decisions are made. Principles around public transparency, the way in which councils make decisions and access to council documents, as well as strategic planning, financial management and service performance principles. So they're guiding principles for decision makers, whether that be the council through a meeting or through the decision of a delegate. I just want to finish off this section on fundamentals, Local Government 101, if you like, by looking at the role of the mayor, the role of the councillor, and then role of the CEO. And I'll pause at that point. And if you've got any questions or comments, by all means ask them or speak up. You'll see the role of the mayor is set out on the screen. It's taken from section 18 of the new 2020 Local Government Act. The role of the mayor has changed as a result of the new Act. Again, if you look at subsection 1, paragraphs A and B, unsurprising, the mayor has always chaired council meetings and been regarded as the principal spokesperson for the council. If you go all the way down to I, it's always been the case that the mayor performs civic and ceremonial duties on behalf of the council. But some of what's in the remaining paragraphs is quite new and reflects a very deliberate parliamentary intention to give the mayor a more enhanced role. So the mayor is to lead engagement with the municipal community on the development of the council plan, to report back to the municipal community at least once a year on the implementation of the council plan. The mayor's role is to promote behaviour among councillors that meets standards of conduct set out in the Councillor Code of Conduct, and I'm going to turn to that in just a moment, to assist councillors to understand their role, and you'll see an H to provide advice to the CEO when the CEO sets the agenda for a council meeting. So it's not just a case of being the spokesperson for the council and chairing a meeting. The role is now greater than that, and in fact, the mayor is given limited executive power. So under the new Act, the mayor is given the power to appoint a chair of a delegated committee if you decided to establish a delegated committee. I should say the council also has that power, but the mayor can decide who the chair of a delegated committee is to be. The mayor can also require the CEO to report back to the council on the implementation of a council decision which has been made. And the mayor is also able to direct a councillor to leave a meeting if the councillor's behaviour means that the council can't conduct the business before it. So limited executive power conferred on the mayor. And if the council decides to have a deputy mayor, then when the mayor is absent or unable to perform their role, then the deputy mayor steps in and has all the powers of the mayor. So I can turn to councillors. You'll see again under the new Act, the role of a councillor is spelled out. It's spelled out in section 28, subsection 1. You'll see in A, it's to participate in the decision making of the council. I emphasise the word participate because that reinforces something that has probably become clear from what I've said as to the way in which councils make decisions. There isn't an ability on the part of an individual councillor to make a decision on behalf of the council. There can't be a delegation to a councillor, including the mayor. So the way in which councillors make decisions is collectively at the council table through a resolution, and hence the reference to participating in the decision making of the council. And you'll see in paragraphs B and C, the role extends, of course, to representing the municipal community and contributing to the strategic direction of the council. You go all the way down to the bottom. Importantly, you'll see also that the role of the councillor does not include the performance of any of the responsibilities or functions of the CEO. And I'll come to those in just a moment. But the role of a councillor is in part positively stated, participating in decision-making of council as well as doing some other things, but is also stated negatively in the sense that a councillor can't do any of the things that the CEO is meant to do. And what are those things? What are those things set aside for the CEO? They're to be found in section 94 capital A of the 1989 Local Government Act. And you'll see a list of things there that are the responsibility of the CEO to establish and maintain an appropriate organisational structure, to ensure that decisions of the council are implemented without undue delay. The CEO is responsible for the day-to-day management of council's operations. And if you go down to subsections 2 and 3, you'll see also that the CEO is responsible for staff matters, for hiring people or firing people or performance management in between. Now, that's not to say you as councillors have no role in relation to employment, because you must oversee and review the performance of the CEO. So to that extent, there is some employment role for you, but for everybody below CEO level, that's the CEO's patch. It isn't part of the role of a councillor to become involved in it. Okay, that's all I wanted to say about local government fundamentals. Key takeaways: limited ways in which decisions can be made, very distinct roles for mayor, councillor and CEO. I'll pause there. If anyone has any questions or anyone would like to say anything, now's your opportunity. Any questions from anyone? If there's anything that isn't clear to you, by all means, speak up. Okay, I'll take that silence as meaning that all of that is at least reasonably clear. So I'm going to move on to the second of the three things that I wanted to cover this evening, and they're the councillor conduct obligations. Now, even before the Local Government Act 2020, there were, in the 1989 Local Government Act, some things about councillor conduct, including a requirement that every council in Victoria have a councillor code of conduct. And so Brimbank had, and still has, a councillor code of conduct. There's been criticism of codes of conduct and their effectiveness over the years. Some people have criticised them because they regard them as toothless tigers, not really worth the paper they're written on. Other people have criticised them because they've given rise to tit-for-tat complaints. Councillor A says that Councillor B was rude to them at a meeting. Councillor B alleges that Councillor A was rude to them at a meeting. And off on a journey go those two councillors, alleging that each other has breached the councillor code of conduct in circumstances where the evidence might be flimsy and in any event the consequence of the behaviour is negligible. So there's been some criticism around really what these councillor codes of conduct achieve. What the 2020 Local Government Act has done is to say each council must still have a councillor code of conduct. Each council must adopt a new councillor code of conduct by the 23rd of February next year. And until that happens, each councillor is bound by the council's existing councillor code of conduct. So you're bound by the code of conduct that was adopted in the previous term of the council, but you'll have an opportunity in coming weeks and months to help develop a new councillor code of conduct. And that new councillor code of conduct will be required to have 4 standards included in it. These are the prescribed standards and a part of the government and parliament's attempts to be more rigorous in the requirements of conduct and behaviour that councillors are meant to observe. So here are the 4 standards, or at least on that page are the first 2 standards. You look in black, you'll see the first standard is that councillors must treat other councillors, members of council staff, municipal community and members of the public with dignity, fairness, objectivity, courtesy and respect. And how do they go about doing that? Well, by, among other things, taking positive action to eliminate discrimination, sexual harassment, victimisation, by promoting gender equality, by not engaging in abusive, obscene or threatening behaviour in their dealings with members of the public or council staff or other councillors. So the first standard is basically one of treating others with dignity and respect. The second standard, which you'll see to the right, again in black, is to do everything reasonably necessary to ensure that a councillor performs the role of councillor effectively and responsibly. And again, how does a councillor live up to that standard? By undertaking any training or professional development activity that is decided is necessary for them to effectively perform their role, to, among other things, conscientiously perform the role of a councillor and to represent the interests of the municipal community by having regard to the diversity of interests among that municipal community. So the second standard is one of doing everything that's reasonably necessary to ensure that you perform your role both effectively and responsibly, including by undertaking ongoing training. The third standard, which is on the next page, you'll see is to ensure the good governance of the council. And how do you do that? You do that by complying with various policies. There'll be policy or protocol or practice that will govern interaction between councillors and staff, but also have an expense policy about reimbursement of expenses. There are the governance rules that I mentioned earlier that go to the conduct of council meetings and decision-making processes more generally. And then there's the possibility of the Minister for Local Government giving directions that need to be observed. So the third standard is around good governance by complying with various policies and other instruments. Then finally, the last standard is to not discredit or mislead the council or members of the public. And how do you do that? You do that by ensuring that your behaviour doesn't bring discredit to the council, and you do it by not deliberately misleading the public or others about a matter that involves the council. So those are the 4 prescribed standards that must appear in the Councillor Code of Conduct. It's said that none of that is meant to limit or in any way impair robust debate. So it's expected that you will disagree from time to time among yourselves and have sometimes perhaps very opposite views from other councillors. That's fine. What's important though is that those views are expressed in a respectful way and that decisions of the council are respected and not undermined. That's what those 4 standards of conduct largely go towards. What happens if somebody says a councillor has not lived up to one or more of those 4 standards? What happens? What happens is that it's open to another councillor or a group of councillors or the council itself by resolution to cite that councillor for breaching the councillor code of conduct, to allege that they've engaged in an act of misconduct, in other words, a breach of the councillor code of conduct. And they do that by making an application, and that application, interestingly, is now to go to a state government official known as the Principal Councillor Conduct Registrar. And that state government official, that registrar, looks at the application for a couple of reasons. First of all, to make sure that there's some evidence there of the alleged breach, that it's not simply been made up. And secondly, to make sure that it's not frivolous or vexatious. You remember what I said a moment ago about codes of conduct being criticised and councillor code of conduct processes being criticised because there were often tit-for-tat disputes. This is a means of trying to weed those out because the registrar acts as something of a gatekeeper. And if the registrar keeps the gate open, then the application proceeds. Somebody external to the council comes in. The person is known as an arbiter, and they're drawn from a list of arbiters on a state government list. And that arbiter hears from those making the allegation of breach, hears from the councillor alleged to be in breach, makes a decision about whether there has been a breach, and if there is a finding of misconduct, then the arbiter decides what penalty is to apply. The penalties can range from suspending a councillor for a month through to directing the councillor to undergo training or, for example, to apologise to another. So that's the process that applies when the councillor code of conduct is said to be breached. You'll notice it's not open to a member of the public to cite a councillor for a breach of the councillor code of conduct. A member of the public can bring it to the attention of councillors, but it's up to a councillor or group of councillors to take up the cudgels and effectively prosecute the matter. Then there's more serious misconduct. And by more serious misconduct, I mean the things which are in the bottom half of that slide. There might have been misconduct alleged against a councillor who's then refused to participate in the process being overseen by the arbiter. They might not have turned up to the hearing. They might not have done what the arbiter required them to do. That is an act of serious misconduct. Bullying, sexual harassment are examples of serious misconduct. Disclosing confidential information or breaching conflict of interest obligations, again, about which I'll say more in a moment, are other instances of serious misconduct. So with serious misconduct, again, what can happen is that an individual councillor, a group of councillors, or the council by resolution can cite another councillor for serious misconduct. So this is conduct that goes beyond those 4 standards I mentioned before. This is more serious stuff. Equally, the head of the local government inspectorate, who's known as the Chief Municipal Inspector, can himself or herself bring a serious misconduct application. Again, that goes before a state government official, this registrar, who weeds everything out to make sure that it's worthy of going further. And if it goes further, again, people external to the council come in and form a councillor conduct panel. Again, there's a hearing. Again, if there's a finding that there has been serious misconduct, e.g. bullying, sexual harassment, disclosure of confidential information, and the councillor conduct panel will decide on the sanction to be applied. That can be, again, everything from suspending the councillor for up to 12 months through to reprimanding the councillor or requiring the councillor to apologise. I did a serious misconduct case, not last year, but the year before. It involved a councillor in rural Victoria who disclosed confidential information. The council took umbrage about that having occurred, and so began a process which led to the councillor conduct panel being convened. they found that the councillor had breached the provisions around disclosure of confidential information, and the councillor conduct panel suspended the councillor. He then appealed to VCAT, which is when I became involved, and VCAT upheld that finding and that suspension. The councillor was suspended for 3 months. So that's an example of the councillor conduct panel serious misconduct process at work. And then the highest level of misbehaviour is gross misconduct, and that's behaviour which really shows that a person is not a fit and proper person to hold the office of councillor. And only the Chief Municipal Inspector, the head of the local government inspectorate, can bring such an application. It goes before VCAT, and VCAT's powers extend to disqualifying the councillor from holding office for 80 years. There's only been one example, I think, in Victoria where that's occurred. It was a former councillor from the city of Greater Shepparton who had a series of misdemeanours, including assaulting members of council staff, certain firearm offences thrown in as well, and he was cited for gross misconduct and was disqualified by VCAT from continuing to be a councillor. So what are the key takeaways again? There's a councillor code of conduct with these new standards that are meant to be observed. Don't observe them and there's a process that is followed that can lead to a misconduct finding. Then there's serious misconduct, which has disciplinary consequences and possible suspension for up to 12 months, e.g. disclosing confidential information, bullying, sexual harassment, not disclosing a conflict of interest, and then most extreme level, gross misconduct. I just want to finish off this part, looking at conduct obligations, by moving away from a disciplinary process to looking at where there are offences in the Local Government Act for councillors who don't observe certain obligations. And there are 3 provisions in the 2020 Act that are criminal offences. The first is for disclosing confidential information. So if a councillor intentionally or recklessly discloses information which they know or ought reasonably to know is confidential, they commit an offence. Now, what's confidential information? There's a list of things in the 2020 Act which tells us what is confidential information. It's quite an extensive list. I think most organisations will try and help councillors by effectively designating the information as confidential, making it clear that in the eyes of the council administration at least, what you're being given is confidential information. So it gives you a fair idea about whether it meets the definition in the Act. So disclose confidential information, it's not only serious misconduct, it's also an offence. You can be prosecuted by the local government inspectorate, and there's a penalty that attaches to it, a fine of up to just under $20,000. Second offence is for directing council staff. So the councillor is prohibited from directing a member of staff as to how they make a decision under delegation or how they make a decision as an authorised officer. You can't say to them, for example, you must withdraw that infringement notice, that parking ticket, which is given to somebody. And there's a prohibition on a councillor directing a member of staff about what advice is to appear, including appear in a council report. That too is an offence, similarly punishable by a fine of just under $20,000. Then lastly, there's an offence of misuse of position, which I mention because it's the one offence provision that carries a term of imprisonment. You'll see right down the bottom of subsection 1, that there's a penalty of 600 penalty units, which is just under $100,000, or 5 years imprisonment for anyone who is or has been a councillor if they intentionally misuse their position. I'm just going to stop there before I read on. how do you misuse your position? If you go down to subsection 3, that's giving you some examples of how somebody who is or has been a councillor can misuse their position by making improper use of information which you've acquired only by virtue of being a councillor, disclosing confidential information, directing or improperly influencing or seeking to direct or improperly influence a member of staff, get down to using public funds or resources in a manner that's improper or unauthorised. So those are ways in which a councillor can misuse their position. That's the first element. The second element is if they do it for the purpose of A, gaining or attempting to gain, directly or indirectly, an advantage for themselves or for another person, or B, to cause or attempt to cause detriment to the council or another person, the offence is made out. So misuse of position for one of those prohibited purposes. And from time to time, fortunately not very often, the Local Government Inspectorate has prosecuted councillors for a breach of this provision. It hasn't led to anyone becoming imprisoned, but it has led to findings of guilt or convictions. So quite apart from councillor code of conduct and the disciplinary things that hang off misconduct and serious misconduct and gross misconduct, you have these criminal offences that are lurking there, and it's important that you understand that they exist and that the Local Government Inspectorate is there to keep councillors honest and respond to complaints from anyone, including people anonymously, that a councillor has breached one or more of those offence provisions. Okay, again, let me stop there because that's the second thing covered. Does anyone have any questions around conduct, any of those conduct obligations that I've spoken
Mark, got a question.
Yep.
So what happens when multiple councillors carry misconduct, and how drastic does it have to be for a council to go into administration, for example, like the city?
Yeah, there's no bright line about when things have spiralled out of control sufficient for the state government to intervene. It does require, I think, quite dysfunctional behaviour over a sustained period ordinarily for the state to step in. But certainly if you had multiple councillor conduct panel hearings and multiple misconduct applications being brought, councillors at war with one another, it's a slippery road to state government intervention. I'm sure in subsequent sessions, Helen and others will speak about the importance of working as a team and collaborating with one another. Tonight I'm looking at the dark side, unfortunately, of when things go wrong. But if you work together as a team, again, I make the point you won't always agree on every issue from time to time, but if you respect one another and respect the ultimate decision, you won't have these sorts of disciplinary or other processes going on, and there won't be any prospect of intervention by the state. Does anyone else have a question or comment? I am going to test you on all of this at the end, so just be warned, it's important that you understand. Helen's shaking her head as if I'm joking, but you'll see in a moment I'm not. Okay, let me move on then to councillor integrity obligations. This is the final thing that I want to cover, though I do want to cover it in a fair amount of detail. The Local Government Act regulates conflict of interest at meetings. And what I'm going to focus on in just a moment is what is a conflict of interest and precisely at what meetings do those conflict of interest provisions apply. Before I do that, I want to mention, though, another legal principle that you will not find in legislation. It's not to be found in the Local Government Act, for example. It's the principle of natural justice. The common law, in other words, judge-made law, decisions that have been made by the courts over centuries, have established a principle, or principles more precisely, of natural justice, such that when those principles apply, the decision maker, the council, has to be impartial, just as importantly, be seen to be impartial. Let justice be done and be seen to be done. And a council will not necessarily be impartial or be seen to be impartial if one of the councillors has a prejudgment about the issue before the council, if they approach the issue with a closed mind. It's what we call reasonably apprehended bias. The impartial, fair-minded person looking in might conclude that the councillor has already made up their mind about the issue, has predetermined it, has prejudged it, and in turn denied somebody the impartiality to which they're entitled, and therefore denied them natural justice. How does that work in practice? Let me give you an example. Returning councillors will know the name Winky Pop. It's perhaps a name known to some of you as well, because it's the name of a case. But some years ago, a case went to the Supreme Court of Victoria, and it involved a councillor at the city of Hobson's Bay, just to the south of you, so taking in Altona, Williamstown area. There was a proposal that an area within the city of Hobson's Bay be rezoned from industrial to residential. A councillor at the city of Hobson's Bay, Councillor Peter Hempel, who I notice has just been returned at the election, had very strong views about that rezoning proposal. So strong that he decided to put in a submission to the state government planning panel that was set up to consider whether the rezoning should go ahead, whether the planning scheme amendment should proceed. And not only made a submission, he turned up before the panel to speak in support of his submission. He said the rezoning should go ahead, but not as extensively as proposed. And for example, the land owned by Winky Pop Proprietary Limited should not be rezoned from industrial to residential. That was his submission. And the planning panel accepted that. It actually agreed with him. And so it published a report recommending that the amendment go ahead, but in a revised form, with the rezoning taking out the land owned by Winky Pop Proprietary Limited. The report of the planning panel went back to the council, to the city of Hobson's Bay, because the council had to make a decision whether to adopt the planning panel report and thereby continue a process that might lead to the planning scheme amendment being approved by the Minister for Planning. When it went back to the council, by 4 votes to 3, the council decided to adopt the more limited rezoning contended for by Councillor Hempel and in turn Planning Panels Victoria. 4 votes to 3, Councillor Hempel was part of the majority. Winky Pop Proprietary Limited, understandably, was pretty peeved about what had happened, and so it challenged the validity of the council decision in the Victorian Supreme Court. It said, we have been denied natural justice. Why? Because there's reasonably apprehended bias tainting the council decision. Why? Because one of the councillors approached the issue with a closed mind. Look at what Councillor Hemphill had done and said. It's clear that he had prejudged the issue, and such was the effect of that, they said, that it meant that natural justice had been denied to them and that the decision was invalid. And that's exactly what the Victorian Supreme Court held. And that's not to say that a councillor can't form a view before a council meeting about an issue. In fact, you're expected to form views before council meetings. And it's not to say that you can't, from time to time, express privately or even publicly on occasions a view about the matter that's coming before the council. But if it's clear from what you have said or what you have done, in the case of Councillor Hemphill, both what he'd said and done, that your mind is already made up, you're not prepared to look at what's said in the officer report, you're not prepared to consider what might be said around the council table, there will be, from time to time, a problem, because it might mean that the council decision that ultimately emerges through the resolution is legally vulnerable. I'm not going to say anything more about reasonably apprehended bias tonight. I just wanted to bring it to your attention as relevant to your role as a councillor, but separate from conflict of interest. So what I want to spend the rest of the time doing now is looking at conflict of interest under the Local Government Act. And again, those of you who have been councillors previously would have seen many changes in this space. I think probably councillors like Sam, a bit like me, can go back to the days of pecuniary interest when it was all about whether councillors had a monetary interest in the matter. But after a while, the Parliament thought, well, that's a bit too narrow. We need a broader concept of conflict of interest. And so it amended the 1989 Act to distinguish between interests on the one hand and conflicts of interest on the other. And that confused everybody, and so that didn't last very long. And so the 1989 Local Government Act was amended again to introduce a conflict of interest regime that distinguished between direct interests on the one hand and indirect interests on the other, in terms that were very prescriptive and quite complicated. And so what the government, the Parliament has decided to do, they say, is to introduce a simplified conflict of interest model under the new Local Government Act, and to strengthen the obligations of councillors in relation to disclosing a conflict of interest. So deliberately trying to make it simpler, but also deliberately intending that the obligations be more onerous. I will leave it to you by the end of the session to work out whether what we have ended up with is indeed a simpler model of conflict of interest. I myself have doubts about that. The new model is one where there are two categories of conflict of interest: general conflict of interest and material conflict of interest. I'm going to take you through both in a moment. But just before I walk you through both, I just want to explain when these conflict of interest provisions apply to you as councillors. So we just go to the next slide. These provisions kick in when you are at a council meeting. If the council were to have a delegated committee or community asset committee, equally they would apply to you then, but I suspect it's going to be the first and last dot points that are most relevant to you. So at a council meeting, or at what's called an auspiced meeting, a meeting conducted under the auspices of council. What does that mean? It certainly means briefing sessions. So your planning forum, for example, your strategic briefing session, any other informal gathering of councillors, what we used to call assembly, councillors. It's that sort of forum. If the council sets up advisory committees and a councillor is present at an advisory committee meeting, that's a meeting conducted under the auspices of the council. If the council's meeting jointly with another organisation, that too is an auspiced meeting. And I think that if there's a site meeting organised by the council itself, that too would be an auspiced meeting. So if there's a planning controversy and you're asked as a councillor to attend the site and inspect it, for example, then that too would fall under the banner of an auspiced meeting. So in any of those situations, the conflict of interest provisions I'm about to take you through will apply. I should say separately, these provisions also catch members of staff when they make decisions under delegation. So it's not as though you're being singled out because staff members are caught by these provisions as well. So let me look at the first category of conflict of interest. It's a general conflict of interest. And according to section 127, subsection 1 of the new Act, a relevant person, read for that a councillor, has a general conflict of interest in a matter if an impartial, fair-minded person would, not might, would consider that the councillor's private interests could result in the councillor acting in a manner that's contrary to their public duties. So this is perceived conflict of interest, tested objectively by reference to what an impartial, fair-minded person would consider. Now, you might think when you look at that, that that's the pub test by another name. What would the man or woman in the pub conclude about a councillor's position in particular circumstances? In fact, I think the test, fortunately, is a bit more sophisticated than a pub test. I say that because the reference to an impartial, fair-minded person is a reference that's very familiar to lawyers because it is exactly that fictional person, that hypothetical person, who is used in cases of reasonably apprehended bias. So in the Winky Pop type case, what a court asks is whether an impartial, fair-minded person might conclude that the councillor has not approached the issue with an open mind. The same concept is being used here with conflict of interest. The same hypothetical observer is being used to decide whether a conflict of interest exists. So it's not a test of whether that person considers that there might be a conflict between private interest and public duty, but rather whether there would be one. And we're told in those cases dealing with reasonably apprehended bias that the impartial, fair-minded person is a person who has a detailed knowledge of all the facts, perhaps unlike the person in the pub. It's a person who we're told will give careful consideration to the issues and not make snap judgments. It's a person who will take a balanced approach. It's a person who is neither complacent nor unduly suspicious. So if you know a person like that, that's the person to ask as to whether you have a conflict of interest. And if you know a person like that, perhaps you can introduce them to me, because I'm not sure I've ever met such a paragon of virtue. But it is be tested by reference to what they would decide. It's important to note that in that test, private interests are defined to exclude opinions or beliefs. So a councillor's opinions or beliefs aren't private interests. But equally, I think it's important to note that friendships and other relationships are. If there was one thing that was clear about conflict of interest under the 1989 Act, it was that friendships could not, without more, give rise to a conflict of interest. If there's one thing for certain about the new provisions, it's that friendships can give rise to conflicts of interest through the general conflict of interest concept. I next want to turn to material conflict of interest. And then what I'm going to do after that is just talk about some exceptions or exemptions. And then we're going to work our way through some examples to just show you how all of this comes together. And once we do that, just to give you a roadmap, to use that word used by the Premier in recent months, we're going to look at what happens if you have a conflict of interest. So at the moment, we're looking at whether you have one. We've looked at general conflict of interest, the word's perceived conflict of interest. Let's now move to material conflict of interest, which is the other category. Again, it's in the new Act, it's in section 128, subsection 1. You'll see it says that a relevant person, again, read for that, councillor, has a material conflict of interest in respect of a matter if an affected person, so read for that, the councillor themselves, or one of the people or entities listed in the second half of that slide. A family member of the councillor, company in which the councillor holds office, or another body in which the councillor holds office, the councillor's employer, a business partner of the councillor, a client of the councillor, down the bottom, a donor of a disclosable gift. In other words, a person who's given the councillor $500 or more during their term on the council. They are all affected persons. So if the councillor themselves or one of those persons or entities would gain a benefit or suffer a loss, depending on the outcome of the matter before the councillor has a material conflict of interest. And we'll see from subsection 2 that that benefit or loss can be direct or indirect and can be pecuniary or non-pecuniary. Now, even though it extends to non-pecuniary benefits or losses, I think for the most part you can equate material conflict of interest with somebody making money or losing money on the basis of the decision that's going to be made at the council meeting, or on the basis of a discussion that's going to be had at an auspiced meeting, e.g. councillor briefing. Okay, so that's material conflict of interest. Just before we come to the examples, I want you to appreciate that even though it might fall within the general conflict of interest category or the material conflict of interest category, there are some exemptions. And if you fall within one of these exemptions, no conflict of interest. If the prospect, for example, of gain or loss for somebody is too remote, too hypothetical, too speculative, or it's insignificant, it doesn't amount to a conflict of interest. What's an example of that? Bruce tomorrow walks down the street, runs into somebody he knows, has a wager for $20 on the outcome of the first test between Australia and India. Bruce wins the bet. He's owed $20 by somebody who's slow to pay him. That somebody is an applicant or an objector to a planning permit application coming before the council at its December meeting. Now, that would not, strictly, you might say, well, there's a material conflict of interest because if their application succeeds or their objection succeeds, that might lead to them having a property that's worth more or worth less. That might make it easier for Bruce to be paid his $20. It's a stretch, but it's logical, but it's so insignificant that it would not count. Secondly, you might not know and ought reasonably have no way of knowing whether you had an interest. Now, this is particularly relevant with family members. If you've got a family member who has tucked away some shares in a company that have never been disclosed to you, or they own a block of land that you knew nothing about, couldn't be expected to know about, then no conflict of interest. If your interest is the same as everyone else in the municipality, or at least a substantial proportion of others in the municipality, in other words, you have an interest in common with many others, no conflict of interest. And if the council appoints you as its representative on an external body, which you get no extra remuneration, and there's some issue coming before the council concerning that outside body, you're deemed not to have a conflict of interest. Okay, so just bear in mind, there are some exceptions or exemptions at work that might mean that no conflict of interest exists, general or material. Okay, I just want to now move to the examples and work our way through those, because I hope that by the time we do that, this will become clear, or at least clearer to you. And it's probably a vehicle for you then to ask any questions you want to ask, hypothetical or otherwise, about your own situation or the situation of others. Now, this is where I'm going to test you, but if I was in a room, I could actually look at somebody and they'd feel prompted to answer, but it's harder to do that on a screen, so I'm just going to depend on people being willing to be volunteers and to speak up. So let's look at the first example. Councillor A's friend is an applicant for a planning permit. Let's assume it's a council meeting, that planning permit is up for consideration. On the face of it, conflict of interest, yes or no, general or material. Somebody want to have a go?
I think it sounds like there'd be a conflict.
Yep.
A general conflict.
Yep, I think that's right. I should say I think there are friendships and friendships. I think there are obviously close and intimate friends, and then there are people who are friends bordering on acquaintances. And if you ask me where's the bright line there, I'm not sure that there is one, but I think in your gut you will know whether you are close enough to somebody else to know whether there's a basis for a perception in the minds of impartial, fair-minded people about whether there might be a conflict between your relationship with that person and your public duty to consider the planning permit application on its merits. So we need to know more facts, but on those facts you'd say probably a conflict, general conflict of interest. That's right. Second example, similar but slightly different. It's Councillor A's spouse who has a friend who is the applicant for a planning permit. Same or different result, do you think?
The same.
Same result?
I think it might be a bit different because it's not direct.
Yeah, it's indirect, that's correct. Again, we're in, go on.
Sorry, Mark, I was going to say, but I am concerned about the perception
Yep.
of other people. So
Yep.
that makes perhaps.
Yep, and that's what you come back to, that's correct. Again, we'd need to know more facts, really, if there may be a close friendship between the spouse and the planning permit applicant, or it might be a loose friendship, and it might be that Councillor A has hardly ever met the friend of the spouse, in which case it becomes more doubtful, I think, that the impartial, fair-minded person cognizant of all of the facts would decide that there's a conflict. But on those facts, there's a basis for saying it's the same answer as in the first example. What about the third example? Councillor B owns a small parcel of shares in one of the big four banks, and that bank, together with the other three big banks, have tendered for council's banking contract? Conflict of interest or no conflict of interest?
Is a conflict of interest.
Yeah, why do you say that?
That's a material conflict, stands to gain.
Yeah, that is right, except for the fact that you then think about the exemptions. And one of the exemptions you might remember is remoteness. And you have to ask yourself, would a decision by Brimbank to either give the tender to that bank or not give it to that bank affect the share price of that bank? And with the greatest of respect to Brimbank, I don't think the decision would impact on the share price. So the remoteness exception would actually kick in. So you're right to say on those facts, material conflict of interest, but in the end, there isn't one, I think, because of an exemption. What about the fourth example? Let's assume that the council has a community asset committee, the role of which is really to manage a recreation reserve within the municipality. And let's assume that Councillor C is a member of that committee, and it's looking at allowing a cricket club to use that reserve. Councillor C is actually a member of that cricket club. What do you think about that example? Conflict or no conflict, general or material? Who wants to go first?
Yeah, Sam, if you want to go first.
Go ahead, Bruce. Go.
Yeah, okay. I think there's probably a difference. As councillors, we tend to be members of lots of clubs, and there'd be a difference there if you're an executive of the club, I think, or greater significance if you're an executive member of the club.
Yep.
But we would probably end up at our time as councillors, members of say half a dozen clubs, wouldn't be unusual. So it depends on whether you're just a ticket holder member or more significant in your role in that club.
Yep.
Thank you, Mark. I likewise, Bruce. I am a member of a number of sporting clubs, as suggested here, and most of the times in the past, I always stand up and declare a conflict of interest. I thought that was the right thing to do, except at times when it's something to do with maintenance, yearly maintenance type of thing that happens to all reserves or all parks, where I believe that type of party had nothing to do with me as a councillor. It's to do with the whole of Brimbank in general.
Yep.
Yeah.
If I had asked this question of you before the election, when the conflict of interest regime was regulated by the 1989 Act, Bruce's answer would have been 100% correct, because there was a distinction between being on the governing body of, say, the cricket club, executive committee, board, etc., and being a mere member. Because again, if there was one thing that was clear under the 89 Act was that being a member of another body did not give rise to a conflict of interest, different if you were on committee or board or executive. That has changed a little under this new regime. Membership does provide a basis now for conflict of interest. There's an exception in relation to family members, but no exception, express exception, in relation to a councillor. Certainly, if you're on the board or executive, it becomes even clearer that you potentially have a conflict, but mere membership can now give rise to a conflict. So the issue becomes, again, what would the impartial, fair-minded person conclude in that example? Is it that the councillor couldn't objectively deal with the issue by virtue of their membership, or is their membership sort of nominal, they don't actually play cricket, it's pretty insignificant, it's too remote a connection? That's the issue. But I think this is much greyer than it was before the new Act kicked in.
Mark, for this instance, like, would you argue that there could be a case for as a common interest, like multiple people, use the recreational reserve and they're representing?
Yeah. Well, if you're asking what happens if you end up with multiple councillors having a conflict of interest, there's in one matter, let's say there's some issue coming before the council about all recreational reserves, and most of you are members of bodies that are users of recreational reserves. There is a procedure now in the Act to try and deal with that situation, and it effectively means trying to sort of hive it off to a delegated committee consisting of those councillors who aren't conflicted by it. But in that example, you could equally say, well, perhaps all the councillors don't have a conflict of interest because it's an interest in common. It's an interest the same as all people who have an interest in recreational reserves. That example is a bit different though, because it's about a cricket club and a councillor who is a member of that cricket club. We keep going. The next example, which is about Councillor D. Councillors asked to note a report coming to a council meeting. The council staff acting under delegation have entered into agreements with various preschool bodies to occupy council facilities. So what's happened is that there's a report coming to the council. The staff are asking the council to note the fact that the council's, for example, leased or licensed various buildings for use by preschool associations. Councillor D has a daughter who will soon be eligible for 4-year-old kinder. On those facts, do you think there's a conflict? And if so, general or material, or no conflict?
I think it is a conflict, a general conflict. And I'm wondering, could it be argued as an exemption for the family member? Or is that
Possibly, although Councillor D, on one view, has an interest as well, namely that her daughter can go to a particular facility. So it's not just the daughter who's affected, but also Councillor D. There are two things about that example which lead me to think it's probably not a conflict. The first is in the first line, the council's being asked to note something. The council's not actually being asked to make a decision about whether council facilities are to be leased or licensed to a body. That's already occurred. The choice is available to the councillor to note it or not note it, and that's not going to affect the occupancy of those buildings. So for that reason, I think there isn't a conflict. Secondly, it just seems to me, first of all, that there'll be a lot of people within Brimbank who have preschool age children, and there might well be an interest in common as well. We go to the next example. We're getting towards the end, but this gives you a flavour for things that are straightforward and things that are not so straightforward. Look at Councillor E, an outspoken critic of the council's record on heritage protection. Councillor E is a member of a delegated committee, so again, assume for the moment the council set up a delegated committee to consider this issue. And that committee is considering a heritage-related planning scheme amendment. On those facts, is there a conflict of interest, do you think?
It sounds like there could be the reasonably apprehended bias.
Yep, that's the first thing to note. Absolutely correct. Quite apart from conflict of interest.
It is a conflict, isn't it?
Well, I'll come to conflict in a moment, but the first issue is there a reasonably apprehended bias issue there? If the councillor has been outspoken about heritage matters, has he or she been so outspoken that it could be said that they have a closed mind about this particular issue? That may or may not be the case. Again, we don't know enough facts, but there is a reasonably apprehended bias issue, that's right. Is there a conflict of interest issue though, as well, do you think?
I don't think so, Mark. I mean, he's or that comes he's or she is an outspoken critic.
Yep,
So there is maybe opinions
yep,
and beliefs.
that's
which
right.
includes-
Yep. Remember what I said before, that private interests do not extend to opinions or beliefs of a councillor. And in fact, when we come to the exemptions, there's actually an express exemption in relation to being a member of a body that has expressed an opinion. So in those circumstances, there might be a reasonably apprehended bias issue. We need to know more, but no conflict of interest. Last two examples, Councillor F, this time is a member of a local heritage protection association, and again, a member of a delegated committee that's considering a heritage-related planning scheme amendment. Let's put reasonably apprehended bias to one side. Conflict of interest or no conflict of interest here?
Conflict of interest. I think it's a
Yes,
conflict
yes
of
or no?
interest.
Sam, sorry, Sam, go on.
I think it's a conflict of interest, Mark.
Yeah,
Being a member of that local heritage protection association, it's involved in a change, so I think it's a conflict of interest.
other people agree or disagree? Or are sitting on the fence?
Hmm.
So are they on that committee as a representative of the council?
No.
Yeah.
Yeah, sorry, our delegated committee is an internal committee to the council. It's not an external body. So they're not a council representative on it. No, it's just like an internal committee of the council.
Yes, conflict of interest.
I tend to lean towards not being a conflict of interest there, Mark.
Yeah. I lean a bit in that direction as well. Again, we would need to know more facts. Membership, as I said before, can be the basis for a conflict of interest. It really depends on what role the Local Heritage Protection Association has had in relation to this particular amendment. If it's had no role or it's simply got a view about it, I don't think that alone would cause the impartial, fair-minded observer to conclude that there's a general conflict of interest. But if there was a greater connection between the association and this particular issue, then I'd agree with Sam. I think a conflict of interest would then exist. Last example, again, building on the heritage stuff, Councillor G's a member of the executive of a local heritage protection association, which has made a submission about the planning scheme amendment. Conflict or no conflict, general or material?
Looks like a conflict to me.
Yep, and to me too. I think it is. I think it's certainly a general conflict and maybe a material one, depending on what consequence the outcome may have for the association, which was a submitter. So I think that's clear, more clearly over the line in terms of the conflict of interest. But do you see how straightforward some examples are, and then there are some which are greyer? There's an old adage in local government that if in doubt, get out. And that means that if there's legitimately an issue or doubt as to whether you have a conflict of interest, you're better to err on the side of acting cautiously, assuming that you have one, and observing the conflict of interest obligations. And you don't want to be silly about it. You don't want to be getting out of the chamber or getting out of a discussion in a briefing just because there's some connection with somebody or something. But if there's enough basis there for legitimately thinking there's a conflict of interest, but you're not sure, you're better to err on the side of getting out. The other thing that you can do, and I'm not sure here whether Helen or Shane or one of the other members of the executive wanted to jump in, but the other thing you can do is seek some guidance or advice from the administration about this. At the end of the day, they can only give advice. It's up to you ultimately to make a judgment about whether you have a conflict of interest and observe the obligations, but they are there to help and support you in relation to all of this. But in particular, this stuff, which is a bit difficult and is new, to try and get a handle on what you think you should do in any given case. So you're not on your own. There are people you can turn to for advice, as well as that impartial, fair-minded person, if you know them, to talk to them as well as to what they would conclude. Just to finish,
I might,
yeah, go on.
I might
Yep.
jump in there to say that's
Yep.
actually the case. And we would provide our advice, but at the end of the day, the responsibility does actually remain with the councillor once we've provided that advice.
Yep.
So as an example, if I was to say to you, I reckon it's a bit tricky, I think it might be, you know, a general conflict for whatever reason, you would then go away and think about that and then make your own decision. Because as Mark said, you have most of the facts. The other thing is that there, from time to time, you will have a conflict, and it's absolutely okay. You can't live and work and breathe and socialise and be active in this community without there things coming up from time to time where you may have an actual conflict, or you may think, oh, perception-wise, it might be better if I leave the chamber or I leave the room. That's completely okay. We've got a process for that. You know, I myself have identified in the future there could be something that I've got a distant conflict with, so I would leave. So it's not actually any big deal to do it because, as I said before, you live and work and breathe in this community. There's a process to do it. The other final thing that I would say is council has a number of policies and decisions that they have delegated to the administration. That means you councillors themselves and the council cannot ever be accused of providing either favouritism or exercising a conflict. That is around sporting ground allocations, allocations of community grants, grants where there is a pecuniary interest that's provided. The council will provide for us the guidelines, then the assessment as to who get those grants is done at arm's length. And it's a really safe way for councillors to do that because you set the high level principles about how you want us to make those decisions. And then those decisions are made impartially and objectively. And nobody can sort of come back at you and say, oh, councillor, you made that decision because it's in your ward or any of those things. So there are a number of protections and policy protections to actually support you, but also protect you from that kind of community perception of any bias or any conflict in your decision making. So that's it for me. And I agree with you, Mark. These are so not easier.
Yep.
The others were pains, but these are not easier.
No, exactly right. Sam?
Thank you, Kelly, if I might. If we go back to Mark, and please, Mark, if you can explain the direct and indirect conflict of interest in a simple way, just an example, if you like, for the fairness to all councillors. A small example, perhaps. Please.
So a direct
and indirect, please.
Yep. So I'll start with direct because that's usually you, for example, owning land, and there might be a proposed development next door, which if it goes ahead will cause the value of your land to increase or reduce. That would be an example of a direct conflict of interest, might be direct material interest. Why? Because directly, you individually will either have an increase in your wealth or a reduction in your wealth. It will be indirect if it's through somebody else or something else that that increase or reduction occurs. So it might be through a family member, or it might be through a company in which you have an interest, which is a separate legal person. So if it's through somebody else or through something else, that's an example of an indirect conflict of interest or an indirect material conflict of interest. Okay.
Thank you, Mark.
Let me just finish off conflict of interest by covering what happens if you've got one. What happens if you're at a council meeting, one of these auspiced meetings, you've got a conflict of interest, general or material, none of the exemptions or exceptions apply, what must you do? Generally, there are two things you must do. The first is disclose that conflict of interest. How do you disclose it? The governance rules. The document I spoke about before, which is concerned with decision making and in particular council meetings, but other meetings as well, it will set out what you must do in order to disclose the conflict of interest, how much detail you need to go into. The second thing that you generally must do is, having made that disclosure, excuse yourself from any further role in discussion or deliberation, or if it's a council meeting, the vote, and any subsequent act implementing the resolution which has been made by the councillors remaining. So you absent yourself and play no role in the discussion, debate, any vote, or any implementation. So those are the two things that you do, and the governance rules will tell us how you go about doing those things. I say generally those are the two things you must do, because when it comes to auspiced meetings, sometimes you won't be able to excuse yourself or absent yourself. It will be enough to disclose the conflict of interest. Remember, I gave you as an example of an auspiced meeting, a site meeting. You go on site to look at a particular site. You can hardly turn up there and say, I've got a conflict of interest, I've got to leave. So in that sort of example, you would generally disclose a conflict of interest, but you could then, having done that, remain and hear and see, because you're not there and then making a decision. But again, it will depend on what the governance rules say. Generally though, it's disclosure and abdication of any future role that are the two requirements. There is a difference between breaching the provision concerned with material conflict of interest and breaching the provision concerned with general conflict of interest. Both, I might say, can give rise to a disciplinary process. Both involve serious misconduct, and the Chief Municipal Inspector, this head of the local government inspectorate, can bring an application for that to be dealt with. But in terms of prosecuting a councillor in a court for an offence can only be committed for a breach of a material conflict of interest, a failure to disclose, a failure to excuse yourself from any further role. There can't be a prosecution of a councillor for breaching the general conflict of interest provision unless that councillor has what criminal lawyers call form in relation to conflict of interest. So if they've previously gone through a disciplinary process for not disclosing a conflict of interest or not abdicating any future role, or they've already been convicted of an offence against that, and the next time that they fail to disclose a general conflict of interest or don't excuse themselves from a role in relation to a general conflict of interest, they then can be prosecuted. But generally, it's only a breach of the material conflict of interest provision that gives rise to an offence. And I should say there are mandatory reporting obligations, not in relation to councillors, but the CEO has an obligation to report any failure to disclose a conflict of interest by a staff member. It's got to be disclosed to the inspectorate. And if it's the CEO who doesn't disclose a conflict of interest or stand aside from any future decision, then the mayor is obliged to report that to the local government inspectorate and to the council. Now, that's all I want to say about conflict of interest. We're on the last leg, just to finish off in integrity by looking at some returns that you're shortly going to have to complete. Before I do that, since we've spent a lot of time talking about conflict of interest, Are there any questions left over that anyone had, or any comments from anyone about conflict of interest? Okay, if not, you've either understood it perfectly, or you're aware that we're getting towards the end and willing me on to keep going, so I will keep going. The returning councillors will remember that when they were first elected, they completed what was known as a primary return, and then twice a year they completed what were known as ordinary returns. And these were returns which set out basically the councillor's interests in various things. Might be shares in a company, might be directorships of a company, it might be information about some other relationship that the councillor felt could give rise to a material conflict between their public duty and their private interests. That set of provisions around primary and ordinary returns has gone. Under the 2020 Local Government Act, there are what are called personal interests returns. They are similar, but quite different. They're similar in the sense that there's a first one that you must complete. It's known as an initial personal interests return. And you have got to complete that within 30 days of having been sworn in. So within 30 days of having taken the oath or affirmation of office, you've got to give to Helen this initial personal interests return. Then, twice a year, between 1st and 31st of March and between the 1st and the 30th of September, you must complete what's called a biannual interests return, covering the period back before or back to your previous return. Okay, so there's an initial one, and then twice a year, there are returns to be completed. And this is all in the name of transparency and all in the name of integrity. It's important that the returns, but in particular your initial personal interests return, be filled out very, very carefully, and you take the time to think and think deeply about what information needs to go on it. I say that for two reasons. First, it's an offence not to put one in on time or to put one in intentionally or recklessly that's incomplete or false. But I say it also because this has been an area of interest for the Local Government Inspectorate. Just before the election just gone, the Inspectorate wrote to a lot of councillors in the state, querying their past primary and ordinary returns and effectively asking them to show cause why they shouldn't be prosecuted under the 1989 Local Government Act for lodging returns that were inaccurate or incomplete. I came to give advice to a number of those councillors who, without exception, were all very honest people who, for the most part, said to me they did it quickly. And with the benefit of hindsight, they didn't think about it as much as they should have. That's why I'm saying do this first one very carefully, set aside the time to do it and do it well, because it's then a template for the biannual returns that you'll put in twice a year. Obviously, with the biannual returns, you'll need to update anything that's changed, but much of the information will be there from your first one. Unlike the previous primary and ordinary returns, which did not require much information, these personal interests returns require you to set out a lot of information. This is part of the more onerous integrity obligations that I spoke about at the outset. So, for example, if you were to have shares in a company, it might be a family company, it's not just a matter of putting the name of the company down on the form. You've got to have the name of the company, its ABN, its registered office, its purpose, its activities. If you've been employed over the last 6 months and have been paid more than $10,000 as an employee, your employer's details have got to go on this form, not just the employer's name, but other details as well. Similarly, if you operate a business and you've had clients who in the last 6 months have paid you $10,000 or more, their details have got to go on these returns. So there is a lot more information that's got to go on. Fortunately, nobody or very few people get access to your returns, initial and biannual. It's really only council staff who need to know, or the chief municipal inspector or somebody like that who gets to see them. But a summary of your returns must appear on the council website. And unfortunately, the price you pay for holding public office is that anyone in the world gets to see a summary of your interests. But it is a summary, it's not every detail, and it won't disclose, for example, the value of shares or the value of any debt that you might owe somebody, or the amount of money that you've received as an employee. That won't appear, or doesn't need to appear, but a summary must appear. Now, I just make the point, as you'll see at the end of that slide, that I'm here talking about returns that are different from another return that you'll soon need to lodge. That's an election campaign donation return that every candidate in the election will need to complete, and they're due early December. That's a separate return from the returns that I've been focusing on, these personal interests returns. Okay, that's all I wanted to cover.
Mark, can I just jump in there and just say to the councillors that we will be sending them the initial personal interest form for them to complete tomorrow. So if they need any assistance, just to give us a yell. So we'll send that through to them to fill out.
Great. And so I say, just take the time this time to think about what's being asked of you and make sure everything is down there. And a bit like conflict of interest and erring on the side of conservatism, it's probably better to put more down rather than less. Okay, that's all I wanted to cover this evening, which I know has been a big dump of information on you. But this is not the only session you're going to have. I think there's a follow-up session in January, late January, which I was going to do, but it clashes with my wife's birthday. So I've actually given my wife preference over you. So one of my partners is going to do that. But I know through experience that what Helen and her executive do is make sure that there are regular briefing sessions with councillors when developments occur. So although there's been a lot to take in tonight, I hope that I've been able to emphasise some key takeaways from it, but some of this will be reinforced early in the new year and then as 2021 develops. Are there any questions though about anything that I've covered or not covered that anyone has? If not, thank you to all of you for your interest and your engagement when I tested you in relation to the conflict of interest issues. And although I know that members of the executive, Neil Whiteside in particular, don't want to have to use lawyers that often, I suspect that over the next 4 years, there may be the odd occasion on which I need to talk to you again. So it will be good in a sense to work with you over the next 4 years. So thank you and good luck.
Thanks, Mark.
Good
Thanks, Mark.
presentation.
Thanks, Mark.
Well done.
It was great. Thank you.
Bye.
See you later.